I can assure you that what you will observe is a vast wasteland.
Try and channel it.
Free and uncorrupted communication.
The pleasure of introducing our panelists for a discussion on challenges to human security. We are honored today with the participation of Dr. Lisa Hajar, Dr. Kirk, and I'm telling you these honorees in the order of their appearance to my left, Dr. Kirk Boyd, Judge Paul Egley, and Mr. Stan Rodin. Dr. Lisa Hajar, a sociologist, is on the faculty at the Law and Society program here at UCSB, as many of you young people may know. She has a doctorate from the American University and a master's in Arab Studies with a concentration in international affairs from Georgetown University. Her current research areas include human rights, international law, and the contemporary Middle East. She is completing a book, Authority, Resistance, and the Law, a study of the Israeli military court system in the West Bank and Gaza, to be published by the University of California Press. Her next major research project will focus on the role of lawyers in the development of international criminal prosecution. Dr. Kirk Boyd attended UCSB as an undergraduate and holds 3 law degrees, I think that may be a world's record, and a doctorate from Berkeley. He has argued in every level of the courts in the United States, including the United States Supreme Court, and I might humbly add that I've had the honor of his presence in my own courtroom, Department 12 of the Santa Barbara Superior Court, the inferior court of all. He is the principal investigator for the International Bill of Rights Project at the Center for Global Studies right here at his alma mater, UCSB. Judge Paul Egley is a retired Superior Court judge from Los Angeles County. His greatest challenge as a judge was to ably and courageously oversee the desegregation of the San Bernardino and Los Angeles school districts. He served in the United States military in the European theater during World War II and was encouraged by German POWs to attend law school, which he did at the conclusion of the law at Georgetown. So you have an alma mater in common. He completed his law degree and returned to Europe to serve as a young lawyer on the American Courts of Occupation. He is the Dean Emeritus of my alma mater, the University of Laverne College of Law, and he still teaches constitutional law there to this day. Last but not least, we have Stan Rodin, who is an esteemed partner at the renowned Santa Barbara law firm of Hatch & Parent. And he is an adjunct professor at Santa Barbara City College in the Political Science Law and Society Department. He served as Santa Barbara County's district attorney from 1975 until 1983, and also was the president of the Chamber of Commerce of Santa Barbara. Managed to do that and practice law. In 1998, he traveled to Shandong University in the People's Republic of China and taught 2 classes to law students there in constitutional and business law. He is also on the California Steering Committee of the Human Rights Watch. Please welcome this esteemed group of scholars and, as Frank Kelly would say, glorious beings. Thank you.
Hello. First of all, I'd like to thank David Krieger and the Nuclear Age Peace Foundation for helping host this, and I'm happy that the Law and Society program here at UCSB could be a part of it. It's the first of many collaborations, I hope. Now, I hate to rain on this ICC parade, And perhaps rain is the wrong word, but if I was going to give a weather report on international criminal justice, I'd say it's overcast in The Hague, but the sun is shining in Brussels. And in a few minutes, I'm going to get to an explanation about what I mean. For decades, human rights advocacy was deemed idealism by political realists, and it was idealistic because it found little resonance or support in political practice. This was most evident in the impossibility to prevent or deter gross violations by holding violators accountable. However, over the last decade, this situation has changed profoundly. International criminal prosecution is a potent marker for the broadening of human rights project from struggles for rights to include struggles against violators. The creation of the ad hoc UN tribunals for the former Yugoslavia in 1993 and Rwanda in 1994 breathed new life into the all but moribund international criminal law, which had been consigned to the realm of legal theory and moral rhetoric since the closing of the Nuremberg and Tokyo tribunals. As a result, once vague principles have obtained greater clarity through the processes of creating the statutes for the UN tribunals and the ICC, and the law has been strengthened through use in a growing variety of venues. In light of these developments, the idealist mantle might be passing to new hands. For example, realist par excellence Henry Kissinger, in a 2001 Foreign Affairs article titled "The Pitfalls of Universal Jurisdiction," writes critically about recent efforts to prosecute violators in foreign national courts, using the case against Chilean dictator Augusto Pinochet as his primary example. A striking aspect of this article is the subtext of fear, and for anyone who hasn't read it, you should read it, it's fascinating. Although Kissinger makes no mention of it in his Foreign Affairs article, in 1998, after Pinochet was arrested in London on a warrant by a Spanish judge, he felt compelled to contact the US State Department to inquire whether he would be safe if he traveled to Europe. His fears, as it turned out, were well-founded. On May 31, 2001, Kissinger was in Paris when he was summoned for questioning before a French magistrate for his role in Operation Condor, the multi-country campaign of state terror in Latin America. He refused to answer the summons and left the country. He's also wanted for questioning by Argentina and Chile. But the fact that Henry Kissinger, whose legacy is built on the traveling show of shuttle diplomacy, could be afraid to travel and at risk when he does, signals a shift of potentially monumental importance. At minimum, his fear raises questions about whose visions and priorities are realist now. The Pinochet case was so important, as Kissinger understands, because it demonstrated that sovereign immunity can no longer provide a shield from legal action, and raison d'etat is no longer a plausible defense for officials facing charges of gross violations. According to Christopher Hitchens, there is now no reason why a warrant for the trial of Henry Kissinger may not be issued in any one of a number of jurisdictions where the law is at long last beginning to catch up with the evidence. Against the backdrop of the Pinochet case, we can understand Kissinger's fear, yet he clings to the arrogance of power that is his stock in trade, implying that what is good for Henry is good for the world. He uses the platform of foreign affairs to ring the alarm, warning readers that chaos will ensue if national courts embrace and utilize universal jurisdiction to prosecute public officials of other countries for gross human rights violations. I agree, and want to briefly outline an argument about why Henry Kissinger should be afraid and why the ICC is not the best means of achieving that goal. Prosecutions and punishments are forms of legal violence. International criminal prosecution represents an unleashing of the violence of law against new targets, namely state agents, including heads of state. The case against Pinochet is part of this trend. It often is analyzed and discussed in connection with prosecutions in international venues, particularly the ad hoc UN tribunals. And it is lauded as a precursor to the ICC, which came into being on July 1st. Together, international criminal prosecutions are seen correctly as recuperating the Nuremberg legacy by attaching individual responsibility and liability to crimes of state. But the Pinochet precedent has some distinctive ramifications. And the one that I wish to discuss is the deployment of universal jurisdiction to prosecute public officials in foreign national as distinguished from international courts. I want to tease apart a distinction between universal and international, and compare their utility to the goal of international justice. Insofar as international criminal prosecution poses a threat to state sovereignty, the Pinochet case stands out because he was a former head of state and because he was made to face criminal charges in a legal system other than his own. In Chile, Pinochet enjoyed an immunity of his own making, but when he traveled, he became vulnerable. When a warrant was issued for his arrest and then acted upon by the British government, he was stripped of his claim, or right-wing critics of the indictment would say his right, to immunity as a former head of state. The Pinochet case became a precedent because of his political status and because of the willingness of a foreign national court to regard that status as irrelevant. However, the charges against him that held up were restricted to the crime of torture and contingent on the time frame of enabling legislation in Britain. In this regard, the British law lords got the law wrong. But the Pinochet case had a larger precedential effect of clarifying and fortifying the principle of universal jurisdiction for gross violations. And this has theoretical and practical implications, which I would note bring to the fore sharp differences of opinion and debates about justice among international lawyers and human rights advocates. How and where should justice be pursued, and who decides if justice has been done? If demands for justice cannot be satisfied or pursued at home, is the deployment of universal jurisdiction in a foreign national court a legitimate alternative? A group of international law scholars and practitioners, including Richard Falk, gathered at Princeton University in 2001 and 2002 to clarify these issues. And they produced a text called the Princeton Principles of Universal Jurisdiction. The introduction states that the Princeton Principles, and I quote, are intended to be useful to legislators seeking to ensure that national laws conform to international law, to judges called upon to interpret and apply international law, and to consider whether national law conforms to their state's international legal obligations, to government officials of all kinds exercising their power under both national and international law, to non-governmental organizations and members of civil society active in the promotion of international criminal justice and human rights, and to citizens who wish to better understand what international law is and what the international legal order might become. I would argue that beefing up universal jurisdiction from its current status as permissible to an obligation to prosecute would depoliticize law enforcement by depriving political authorities of choice. This is, of course, one reason why political conservatives, whose primary interest is the preservation of state authority, discretion, and sovereign immunity, oppose it. But the practice of law at this juncture is progressive. That is, it's challenging conservatism. The progressive potential for human rights law enforcement is stronger in Brussels than in The Hague, where the new ICC is located. In 1999, the government of Belgium, inspired by the Pinochet precedent, reformed a 1993 law, which itself had been inspired by the creation of the UN tribunals, enabling Belgian courts to be used for the prosecution of gross violations without any connection to Belgium. This latter element goes further than the Pinochet precedent. The Spanish warrant for Pinochet was based on the victimization of Spanish citizens by the Chilean regime. Thus, the relationship between territoriality and sovereignty was preserved vis-à-vis the victims, even as it was challenged vis-à-vis the perpetrator. Had there been no such connection, it's highly unlikely that the British government would have honored the warrant. But because of the connection, the British officials recognized Spain's legitimate interest in trying Pinochet and felt legally impelled to place him in custody, despite harsh criticism for doing so from certain quarters, including Realpolitiker and Pinochet crony Margaret Thatcher. But the lesson the Belgian legislators took from the Pinochet precedent was not the territorial connection in the warrant and extradition request. Rather, it was the extraterritoriality of criminal liability for gross violations. In effect, with its universal jurisdiction law, Belgium was offering up its own courts as a forum for the enforcement of international law and committing resources for the prosecution of a comprehensive range of gross violations. Consequently, Belgium has become the premier national site for international criminal prosecutions. More than a dozen past and present foreign heads of state leaders have become targets of lawsuits in Belgian courts, including, just to name a few, Saddam Hussein, Ariel Sharon, Yasser Arafat, Laurent Gbagbo, Paul Kagame, and Hassan Habre. And because of the ongoing process of European unification, other European governments are contemplating following Belgium's lead with their own national universal jurisdiction laws. Belgium's universal jurisdiction law has had some setbacks, though. In February 2002, the International Court of Justice, which is the court that tries cases between states, rendered a decision in the case of Congo v. Belgium, ruling that a person currently in office, in this case the foreign minister of the Democratic Republic of Congo, alleged to have incited and abetted crimes against humanity during a rebellion against the late Congolese president Laurent Kabila, the ICJ ruled that he could not be indicted by a foreign national court, Belgium, because this would interfere with his capacity to discharge his official duties. Human rights advocates criticized this decision as a step backwards. According to Reed Brody of Human Rights Watch, this ICJ decision goes against the international trend toward accountability for the worst abuses, but it should not stop Belgium from pursuing cases against perpetrators once they leave power. In June 2002, the Belgian Court of Appeals issued a ruling that the case against Israeli Prime Minister Ariel Sharon for war crimes in Lebanon in 1993, that is massacres at the Sabra and Shatila refugee camps, could not proceed. However, this ruling was based not on the fact that Sharon is currently in office, he's the current Prime Minister of Israel, which was the principle advanced by the February ICJ ruling, but that he is not present in Belgium. This decision, however, galvanized a broad-based coalition comprised of Belgian and international human rights organizations, members of the Belgian parliament and government, and victims of war crimes from a variety of countries to act to reverse the ramifications of this ruling. In July, this initiative bore fruit in the form of a political agreement among Belgian parties to put forward an interpretive law to clarify and strengthen Belgium's universal jurisdiction law. The proposed interpretive law has wide governmental support, and passage is anticipated. As these developments in Belgium suggest, the use of universal jurisdiction is in a state of flux. This chaos is productive for legal practitioners and proponents of justice for gross violations. This chaos could also be productive for scholars. However, since most scholarship on international criminal prosecutions is written by lawyers, and legal education and discourse tend to be chaos-averse, there's a palpable ambivalence about the current state of affairs. Even in writings by the most enthusiastic supporters of the prosecutorial trends, there are few examples of enthusiasm for the current chaos as such. International law scholars openly acknowledge the unsettledness of possibilities and imperatives for prosecution. Many devote their energies to formulate arguments that will help settle the future. In this vein, while national legal systems are regarded as legitimate venues, the prevailing preference is international courts because of the greater possibility for uniformity and predictability. The current chaos is treated as a problem to be resolved. In contrast, I join with those dissidents within human rights discourse who argue that universal jurisdiction in national legal systems is preferable to international courts. This preference is not categorical, nor do I reject the utility or legitimacy of international courts. But I am less enthusiastic about international courts because they reinforce state centrism of the international order and prevailing imbalances of global power. And as John Burroughs had clearly stated, some of the factors that went into, the compromises that went into negotiating the ICC at the insistence of the United States, even though the U.S. had no intention of ratifying it, and indeed George W. Bush has gone so far as to remove the U.S. signature from the ICC statute. And as he also mentioned, a number of European governments recently have offered to sign bilateral agreements with the U.S. granting absolute and blanket immunity to Americans from the jurisdiction of the ICC. And for these reasons, I believe the ICC falls far short of a vindication of the plea, never again, nor does it provide prospects for more and better justice in the future. A centralized international system of justice requires consensus, and this is bound to operate more conservatively. In the future, the new ICC will come to dominate this system, notwithstanding its provisions for complementarity with national legal systems. Once the ICC is up and running, there will be greater pressure to channel prosecutions through that venue, or at least to vet prosecutions through some international decision-making process. This will detract from the possibilities of prosecutions, especially of perpetrators from more powerful countries. In contrast, a universal system of enforcement in national systems would be more democratic by empowering countries of varying strengths to contribute to the interpretation and application of international criminal law. Decision-making would be decentered, and judicial rulings in one venue could and probably would influence rulings and outcomes elsewhere. A universal system increases the role for monitors, offers more opportunities for individuals and NGOs to intervene in the legal processes, and promotes the rule of law and international norms by enabling courts around the world to participate actively in enforcement. To illustrate this distinction, I would offer one more lesson from the Pinochet precedent and show how it can be applied to the U.S. In the Pinochet case, the British law lords were influenced by litigation and judicial decisions in U.S. courts on cases involving torture. Filartiga v. Peña is a U.S. landmark case with global ramifications. In that case, a Paraguayan victim of torture successfully brought a civil action under the Alien Tort Statute against his Paraguayan torturer. The case demonstrated the universal jurisdiction for torture through a willingness of the U.S. legal system to accommodate one foreigner's claim against another, albeit that in this case, and indeed most cases in U.S. courts involving international human rights violations, are civil rather than criminal. The Belgian model has serious ramifications for the prosecution of torture when it comes to the U.S. While torture perpetrated by American officials in the U.S. can be prosecuted by domestic law, and while the torture perpetrated by foreigners outside of the U.S. can be the basis for tort action in the U.S., if American officials perpetrate torture or abet torture outside of the U.S., American territorial jurisdiction provides a safe haven unless the government decides to prosecute them, which it never will. Thus, sovereign territorial jurisdiction coupled with governmental refusal to regard international law as binding on us impedes justice for victims of torture by Americans in other countries. American torture abroad, the abetment and enabling, is not a rare or exceptional phenomenon. And anyone who knows anything about the School of the Americas knows what I'm talking about. Those U.S. officials responsible for it should be held to account in the name of the law and in the interest of justice. Although American officials with blood on their hands enjoy impunity within the U.S., they go on vacation. And when they go, they are vulnerable to indictment and prosecution, not in the ICC, but in foreign national courts. Indeed, because U.S. courts have recognized universal jurisdiction for torture, if an American were to be indicted on the charge of torture elsewhere, our government would have no legal basis for opposing it in principle. If this were to materialize, it would go a long way toward enhancing the rule of law in this country by rupturing public ignorance about illegal U.S. policies and practices in other countries and official arrogance that American officials are above the law. In fact, contrary to the claims of those who warn that such a prospect would be a politicized use of law, not prosecuting Americans for human rights violations in other countries is the hijacking of law for political ends. The possibility that Americans responsible for torture and other gross violations can now be prosecuted abroad is the chaos that Kissinger, among others, fear. The chaos has come. It characterizes the present. I'm not suggesting that we elevate this chaos to the status of a new paradigm, only that we appreciate the potential, the utopian potential of the present. This present, this chaos, this utopia will be lost in the future by the good intentions of those pressing for order.
Good afternoon, everyone. I would like to start by thanking David and Chris and the Nuclear Age Peace Foundation for putting this together and making this possible. Both last night and today I found to be very inspiring for the work that we're doing with our International Bill of Rights project. And I think that one of the things that strikes me the most is that when I listen to President Robinson speak, I get the sense of hope that David's been writing about, and that Frank Kelly, I would like to thank Frank Kelly as well, if he were, it would be nice if he was here, because it's that sense of hope and determination that spurs on the motivation to take these aspirations and to convert them into an institution, into something that's actually working. Now, we may have some disagreements or some doubts about what the success of the International Criminal Court will be, but I don't think anyone doubts that it's a tremendous achievement. And that's the type of achievement that's come about through dedication and determination over a period of time. And I think that passage of time, that transformation, is somewhat reflective by Richard's telephone, okay? Which is actually a reminder for me that I was just going to mention what Richard was saying today at this particular time. And that is, and it actually is here in my notes, and that this morning what Richard was talking about, when I'm talking about this transformation, Richard was also talking about a normative evolution or revolution that was occurring in the 1990s for human rights. And his question this morning was whether or not that human rights normative evolution has been derailed by what we are talking about with the Bush administration and what we see happening today, or whether it's just a detour. Okay? And that has really stuck in my head all day long, and I've been using President Robinson's words to try to convince myself that perhaps it's not a derailment, but it's only a detour. And I'm hopeful in part because of the work that we're doing here with our Bill of Rights project. And so let me explain to you why I'm hopeful that it's just a detour. First, and this is what Lisa Hajar mentioned this morning, is that when you look at the Cold War, and Richard mentioned that after World War I we had the League of Nations, after World War II we had the United Nations, and then after Cold War III we had nothing. But we had some things, but nothing like that type of development. Well, when we look at the International Criminal Court, to me it's an indication that maybe there is something. Maybe there is something that can be built on. Maybe this is just a detour. And that's how I see the International Criminal Court as a tremendous success as far as holding people accountable for committing egregious acts. But what I want you to think about with me, and a lot of our work is based on Eleanor Roosevelt's work on the Universal Declaration of Human Rights, is she had this great line that she used to give in her speeches. She said, and I think David knows this one, she said that the future belongs to those who believe in the beauty of their dreams. And Robinson and Wetzel are good examples of that with the International Criminal Court. And the question is, what do we dare to dream beyond that? Well, our project, the Bill of Rights project, is a discussion about what type of rights have developed to the point where there's an overlapping consensus. And I'm not going to go into John Rawls' philosophy that Burley Wilkins is so familiar with, but the idea being that there are some rights that are developing a universal status. And what are they? And what we're suggesting is that there needs to be a discussion about what are those rights, not an assumption that we know exactly what they are. How many of you received this booklet today? I hope that if you don't have it yet, that you'll pick it up. Because along this transformation, if you look at the International Criminal Court as a mechanism for holding people that are accountable for egregious acts, the next step would be, what if you had a Bill of Rights that would actually create societal norms and rights that would prevent those egregious acts from occurring? The idea that you can actually have a set of norms develop, and this is what Eleanor Roosevelt and the others saw that was so remarkable, that when President Robinson says, and this is a quote, and I took this down, this is from that Nazi war criminal. He said, quote, "Rules must be devised whereby mankind can learn to live together." See, fundamentally, that's what Eleanor Roosevelt and the others were working on when they came up with the Universal Declaration of Human Rights. And you could say that there was it a derailment or a detour because that document never became fully enforceable? Well, I like to think of it as a detour. And so now there's a possibility to discuss together about what would be in a document that would really be enforceable. So what does all this boil down to as far as this presentation and your being here, and what slightly separates this presentation and our work from some of the other things? And that is, it's a process. And instead of just telling you about it, we want to encourage you to participate in it. So our process is that we have a website, and it's there on the bulletin board, or the signage that we have. It's ibor.org. And what we're doing is we're seeking to have scholars and students and others all go to the website and contribute their thinking as to what they would choose to be in an International Bill of Rights. One of the reasons why we're doing this is because we want there to be an education about the Universal Declaration and the covenants and people and existing bills of rights in their country. But then we want you, and particularly the students that are in here, along with scholars that are working, to contribute what you would pick. What would you want? What are your expectations as part of the social contract for those that govern? Was Mark McGuinness right? Is there a right to a clean and healthy environment? Should there be social and economic rights, like a right to education, a right to health care? And as part of the predicament that we find ourselves in, where there's so much hatred and animosity and jealousy in the world, the fact that there was somewhat of a derailment for those economic and social rights. They've never been given equal status to civil and political rights. So I slipped in a little bit of my own bias there, but I would want you to think and hopefully to contribute to our project in thinking about what you would want to have in an International Bill of Rights, because we see this as a transformation that's occurring. And when it does occur, and you do have a document that is put into writing, one of the unique aspects of it is that, as Judge de Belfay here referred to her court as an inferior court quite inappropriately. Because I think one thing that's been a little bit lacking here is, while the International Criminal Court is a wonderful achievement, it is very focused as far as having an operation in The Hague. And it's worthwhile. I'm not saying that it's not. But the idea of our project is, what kind of rights would you have if you were to stand in front of Judge de Belfay? Only not just in her court, but what about a court in Canada, or France, or in Lithuania, or in Nigeria? Are there some universal human rights that you should be able to enforce in the local courts of any country? And that's the discussion that we're having. And that's the vision that we're sharing. And I hope that you will participate in it. Because another thing I'd like to just close with, and I don't want to speak for too long because I hope that we'll discuss about rights and think these things through together. But President Robinson said, whether we like it or not, the civilization is being built around us. And that's the truth. We can already see the vision that George Bush and others are espousing, that when our Vice President Cheney tells us this war will not be over in our lifetimes. Okay? This is the way that the new international order is going to exist. Unless we speak up, and without the predetermination about what the answer is, but discuss it together, we won't come to a counter, or at least a clear idea of exactly what it should be. We will be left with that by default. So that's the ultimate power of this project, is that the idea that many of us in different organizations and different universities can focus together on a single document and think together and collectively decide what we expect from those who govern. Thank you.
I have a unique vision, not a unique vision, but I have a unique history. I think it probably extends to not many people who are still alive. I grew up in the 20s when we had finished a war, which was a war to end all wars. And even as a child, and even as a young person going to college and going to high school, I recognized that that was sophistry. There was no question in my mind, and no question in, I believe, anybody's mind, that war did nothing more but breed more wars. And I knew we were going to get into a war, which was the Second World War. And I don't know what we fought for in the Second World War, but I was told at the time that we were fighting to defeat the evil people in the world. And I guess we did. I don't know. At least we had the end of the war, and then after that we had the Nuremberg trials, in which we picked out particular malefactors. We didn't pick out Stalin, we didn't pick out Churchill, we didn't pick out President Roosevelt nor other people. We picked out the losers. And we said to the losers, we're going to try you for wars of aggression, wars against humanity. And the penalty which is going to be paid for finding you guilty is going to be your own culpability. It's going to, as a result of your own culpability, and will be a personal penalty. Now, his personal activities, any one of those people who were there, Speer, Goering, Hitler, I can't recall the rest of them. There were a lot of them. The fellow who was the propaganda minister and so on and so forth. On the German side, all paid for it, either with their life. Hitler didn't. He committed suicide, cheated it. But the rest of them spent some time in the universal jail, in which we had 4 different guards changing monthly, guarding them against escaping. The penalty which they paid was personal penalty. What tribunal paid for or asked for or sanctioned the nations which were engaged in the so-called crimes of which the individuals themselves were complained of, that is, wars of aggression, wars against humanity? Isn't that a national crime, or is that only an individual crime? So believe me, I have come to the conclusion that war is bad, and I was born with that. And I was born with the conclusion that killing was bad, and wars is a form of governmental killing. And I'm opposed to war. I've seen enough of it. I've lived through the World War II. I've lived through the war in Korea, the war in Vietnam, the various little wars that we've had in the United States, in which things were happening, in which some of us were engaged in aggressive wars, and also through the birth of the United Nations. I've come to the conclusion that there is, and there has to be, some sort of a standard throughout the world, sooner or later, in which we agree that we're all part of the world. And if we're going to agree to a part of the world, we have to have certain standards which the world has to conform to. We're not asking individuals to conform to it, because I don't think individuals will. I think once it becomes a national policy that the war of aggression is important, then the individual who's leading that, or who is the president, or is the dictator, or whoever he is, has very little control over the acts that occur during this war of aggression. How do we punish the war of aggression? And do we have any hope in the legal nations for doing so? Who determines whether it's a war of aggression? We find, however, that those are the 3 major factors in the criminal in the criminal code for which an individual may be prosecuted. Which leads me to a very definite conclusion after listening to the speakers at this convention and other speakers and my own reading and my own experience, that the Criminal Code is a wonderful document. It pulls together 60 nations, and perhaps there are more now, who have agreed that there shall be acts which individuals shall be responsible for, in which a criminal court of justice, which will be international, will be the prosecuting attorney, will be the jury, will be the judge, will be the sentencing, will be the confinement portion of this individual act. And what it does what we all know, and we really didn't need the codification to know, that is, what are these acts for which they shall be prosecuted? They're universal. You don't have to be Chinese, you don't have to be American, you don't have to be English to understand what these are. I hate to suggest that perhaps we're going back to natural law, but at least they are so universal, they almost take on the concept of natural law. Consequently, what we have done in adopting the Code of Criminal Justice, what the nations who have signed it have adopted, they've set forth standards. And to that extent, I believe that the criminal court is a good document, it is a good concept. It says that the following acts, all of which reflect the actions of the nations and not necessarily of the individual. These are crimes for which there shall be a punishment, a detriment, period. It sets forth standards which we really don't have in any other document or any other place, except for the documents that you people are asking for and that you're asking for and I'm asking for. But those documents have no sanction. They don't have general agreement. They don't have the coming together of these nations that these are bad things. It's a good beginning. And of course, we're all aware that the reason that the United States haven't adopted it is because there's the possibility that we too may be guilty of such acts. And being guilty of such acts, we don't want to be bound by the rules. Right? It's as simple as that. The evil that I see is the use of force to advance public policy and national policy. That once we get beyond that and we resort then to a different form of negotiation, a different form of getting together and deciding that this is wrong or this is right and abiding by it, and without the necessity of sanction of force, unless it's absolutely necessary as the Code of Criminal Justice defines it, unless those occasions occur, that we can, in the long run, get rid of war. I visited Costa Rica on one occasion, and I was surprised to see the number of schools and no army. And I asked somebody down there about, what's this all about? And they said, they don't have an army. I said, how do they protect themselves? Well, I said, we have a police force, but it's not an army. And what do you do? And they said, it's been a wonderful thing because we've used the money which we normally would have spent it for an army that the normal Central American countries use for their armies. We've used it for education. They have probably the highest literacy rate in the Western Hemisphere. They have the best health care. They have any number of things that other countries don't have because they are available to the citizenry through the use of the funds which ordinarily would have been the army. Of course, I pray for those days. But I do say this, that I don't believe that the ad hoc tribunals that we've instituted, there were a few ad hoc, I think, there were none that I can recall except the Haile Selassie problem during the World War I to World War II. But after World War II, we've had, at least 8 or 9 ad hoc tribunals set up in which the victor makes the rules and the loser pays the penalty. That's not justice. Justice is a reference to a universal principle, and it has to be universal because it extends beyond our boundaries. We, for example, have accepted the grounds that we are subject to some international rules. We have treaties as to wild animals, we have treaties as to some ecology, we have treaties as to commerce. But when it comes down to treaties which involves American citizens, then for some reason or other the United States has backed off. We have one, for example, that talks about the right of the defendant upon committing a crime in a foreign country and subject to a treaty which the United States has given jurisdiction to the foreign country, winning in the Supreme Court on the grounds that this American defendant who was tried and convicted in a Japanese court, for example, was denied her constitutional rights because she was denied the right of a jury of her peers. That's the kind of feeling, that's the kind of national identity that we're dealing with the culture that we have. And until we've changed our culture, until we agree that we are part of the international world and that we are one world and that we must all abide by certain rules, until we are willing to accept that, I think that all the ad hoc committees, all the ad hoc courts, all the treaties that we've entered into bilaterally will have no effect upon what I consider to be our great failing, and that is our inability to settle matters without the use of war. Thank you.
Thank you. I know it's late. I know it's hot in here. I know you're tired, so I'll try and keep this short. But it's a privilege to be able to be both a practicing lawyer and a wannabe teacher, to have the opportunity to review the Rome Statute and to kind of put the lens on of a practicing lawyer, a former prosecutor and defense counsel, and someone who tries cases in the courts all the time, and just ask some questions, fundamental questions about the court. And the first question that came to mind was, how many millions of people have died between World War II and July 1st of 2002 at the hands of others who have never, ever been brought to the courts of justice? It's in the millions. In fact, the answer is it's in the tens of millions. And number two, the principles of international criminal law that would allow nation states to prosecute based on the principles of universal jurisdiction are not inconsistent, I don't think, with the International Criminal Court. In fact, it seems to me, and maybe we can have a discussion about this, that started with an email yesterday and we didn't have a chance to really conclude it, but it seems to me that the people that framed the ICC had in mind to empower nation states to go forward, and so long as they were politically willing to take on the responsibility and capable of taking on the responsibility, and did so with sort of elementary rules of justice, fairness, we would call them, based on international standards, that the nation-state prosecution would have priority and there would be no jurisdiction in the International Criminal Court. And beyond that, there are plenty of situations over which the ICC will not have jurisdiction based on the politics that led to its creation, and nation-states could go forward with those prosecutions. And to say, well, that's should replace the ICC, I think I fall on the line that says we need them both. We need to empower nation states to take on cases where they have the political will and wherewithal to do so, and where they don't, there should be an international criminal court taking on that responsibility. As we know, the court for the former Yugoslavia, the ICTY, the International Tribunal for former Yugoslavia, and this similar court for Rwanda were created because nation states wanted to delegate, and I go back to what John Burroughs said, wanted to delegate their rights under universal jurisdiction to courts to handle them for them, but it took a long time to get them started. And I'm very much influenced by one of the young prosecutors that went over from the United States to the Yugoslav court, Terry Bowers, who was the former Central District United States Attorney and now the Chief Assistant City Attorney in Los Angeles, who was one of the first prosecutors. The advantage to the United States being engaged is self-evident. He went there when there were 5 professionals at the court. It grew to 1,200. It had a budget measured by perhaps a few $1 million to a budget now that exceeds $100 million. He played a central role in its creation. it's important for the United States to stay engaged at the table to bring about the kind of reforms that I think Bill Clinton was alluding to when he signed on to the statute, but indicated that there was room for improvement. So as a prosecutor, former defense counsel in criminal cases, I asked myself, would a prosecutor, just an ordinary average American prosecutor under the state system or federal system, being dropped in to prosecute a case under the International Criminal Court, feel comfortable? Would that prosecutor, he or she, feel at home? Would they understand a lot of the principles and procedures that have been developed that are locked into the statute? And the answer is just a resounding yes, and I apologize if this will take a little while to go through, but I promise I'll make it short. For example, the court requires prompt notice of charges. One of the cases at Rwanda, that lesson came from one of the cases at Rwanda where prosecution was delayed for 22 months without formal charges being filed, and that case was ultimately dismissed. Is there a presumption of innocence? There's a presumption of innocence. Is there a right against self-incrimination? There's a right against self-incrimination. Can any inference of guilt be drawn from the fact that a person takes the right or affords themselves the opportunity to the right against self-incrimination? They may not do that. Is there a right to counsel? There is. Is there a right to bail? There is. Is there a right to an interpreter in the proceedings? There is. Is there a right to a speedy trial, as I've alluded to? There is. Is there a right to conduct the case in person? There is. That's the lesson. Milosevic is conducting his own trial right now. Or the right to counsel? The answer is there is. Is there a right to cross-examine? The answer is there is. Is there a right to discovery? And within certain limits I'll come back to in a moment, there is a right to discovery. That is the right to obtain evidence held by third parties, either to prove guilt or to prove innocence. Is there a right to be free from duress or coercion in the sense of confessions being extracted under means which would violate the conscience, which is basically the standard in this country? And the answer is yes. Is there a right against cruel and unusual punishments? And the answer is yes. Does Miranda apply? The answer is yes. And not only does Miranda apply under the Rome Statute, it applies more stringently, interestingly enough, than it applies in this country. It applies, by the actual words of the statute, to non-custodial investigations. So as soon as the investigation starts to focus on a particular individual who's now under suspicion, the rights of Miranda to be given right to counsel and the right not to incriminate oneself and so forth is given. Is there a right against ex post facto application of the Rome Statute? The answer is yes. Is there a right against double jeopardy? The answer is yes. Is there a right to appeal? The answer is yes. So it seems to me that there are some things missing from this rather lengthy list. The Fourth Amendment, the right of privacy, which has been written into the Fourth Amendment over the last 25 or 30 years, maybe longer than that now, 35 years, is certainly absent per se from the statute. The right to confrontation, there are questions about the use of affidavits instead of live witnesses in the criminal prosecution. There is a right of certain states, nation states, and other third parties to withhold sensitive information which might be useful to the defense or the prosecution. There's no right to compel certain kinds of evidence. There are all sorts of problems and issues not dissimilar from the problems and issues that are faced every day in American courts and in the world courts, whether it's a civil system or a criminal law system. So the real question for me was, is it better to be at the table? I keep coming back to that. Is it better to be at the table and play a role in shaping the International Criminal Court, in attempting to negotiate, not impose, but to negotiate our values of due process, fair play, and justice, than it is to walk away from the table? And the answer is obvious, because when you look back at the history of the negotiations of the International Criminal Court, the U.S. played a central role. And not only was it the largest contingent, but a lot of the things I've touched on today were locked in because of the American advocacy. And second of all, if you don't play at the table, if you won't stay at the table, what do you face in any event? In other words, our constitutional rights afforded within the ICC? The answer is yes. The question is, what happens to U.S. national interests without the UCC? For example, right now, U.S. citizens abroad are subject to the criminal law sanctions of foreign states if they're accused in those states. They have the right to talk about their cases with their consular offices negotiated by treaty, but they are subject to the jurisdiction of those foreign locations in criminal courts anyway. And most of these courts do not afford anywhere near the number of rights that I've just listed under the ICC, including, in most of the world, no right to a jury trial. Number two, the objection about military personnel being subjected to a court. When you compare the military personnel rights under the Uniform Code of Military Justice with the rights under the ICC, I think you come readily to the conclusion that a person charged under the ICC would be secure in more rights than are afforded under the UCMJ, which are considerably fewer in number than those afforded to defendants in the general criminal courts. Next, prosecutorial discretion. John Burroughs touched on that. In my view, and based on my own experience, the idea of prosecutorial discretion is absolute. When a prosecutor reviews a case to decide to file the case or not file the case, that decision not to prosecute is the most powerful decision, and I've always argued a much more powerful decision than any judge ever makes in the system, because that's the place where a case can be kept out of the system, and that decision is not reviewable. Now, I know there are a few cases in the federal system that would take a contrary view, but by and large, every day the working prosecutors make these decisions and exercise their discretion, and when that prosecutor decides not to prosecute, that's the end of the case. Now, if you look at the ICC and you look at the role of the prosecutor, you immediately see that the prosecutor it is not exactly unfettered discretion, as some of the critics would maintain. Yes, the prosecutor receives information from third-party sources or reference from the Security Council or from member states, no doubt about that. Prosecutor then will have an army of investigators aided by the principal investigators are the nation's state personnel and justice departments themselves, and then will make the critical decision to move forward. That case cannot be filed. Unlike the American system and unlike the system in many other places, that case cannot be filed unless it's reviewed first by the pretrial chamber for what they call admissibility. And the test for that would be very familiar to anyone who's ever worked in a U.S. criminal court, the test of probable cause. Is there probable cause to believe that a crime was committed? Is there probable cause to believe that the person accused has committed it? And this is a 3-judge court of the 18 judges that will eventually be appointed to the court that will make that decision by a majority vote, 2 out of 3. So the prosecutor cannot institute a prosecution that does not get the authorization of the pretrial chamber. Last, certainly not least, it seems to me that the subject of jurisdiction, the idea of complementary jurisdiction, is very familiar to American prosecutors. The same discussion they're having back east today about whether the federal government, Maryland, Virginia, or Alabama is going to go forward and prosecute the 2 individuals who were arrested the other day. There is concurrent jurisdiction. There is primary and secondary jurisdiction depending on the nature of these crimes. The same principles, just drawing an analogy, the same principles apply, but by and large, as I said at the beginning, where a nation state wants to go forward, has the political will to go forward, has the resources, and has a basically fair system, then that nation state's justice system will have primary jurisdiction. And frankly, it's hard to imagine that if you read the 1996 War Crimes Act or the 1997 Genocide Convention Implementation Act, that there are really any conceivable circumstances that this complementary jurisdiction wouldn't shield a U.S. citizen from being subjected to. So in conclusion, it seemed to me that the ICC is a good start, that there are some things that need to be worked on, and that the United States can be much more effective at being at the table to negotiate those changes, which is what I think Clinton envisioned, rather than simply turning our back on it and ignoring it. Thank you.
Not only the president, but the Biden resolution and the so-called centrists or moderates or skeptics in the Congress and most of the Democrats have endorsed a point of view of American entitlement, which essentially destroys not just the UN, but the principles that far predate the UN in terms of a global readiness to commit aggression. The Democrats, including people like, I'm sorry to say, John Kerry, who I was proud to have on the back of my jacket for a blurb, which I solicited, and he gave a very good one, and I'm grateful for his doing that. I would not have asked him for that, I have to say, this month, when he shamed himself and his background by saying, if the UN does not endorse this action, we must do it unilaterally, which of course is a position taken by nearly all the Democratic presidential candidates at this point, and which of course is an open assertion of aggression, of aggressive war. Without UN sanction, tell me if I'm wrong, Dick, we're talking about aggression, right? I did not join the Marine Corps in the 50s, and I did not go to Vietnam in the belief that I was a member of a country that would commit aggression. I thought we were against that. But I know that's the theme of your conference, but what I'm especially anxious to talk about is the obsession that I share with David and with Dick Falk and Jackie Cabasso. To put me in the same class of obsession as Jackie Cabasso on this issue may seem presumptuous to those of you who know her and John Burroughs, but it really is true. Can you give me that, Jackie? And it's not funny, of course, because I believe, and I'm saying this quietly because I want it to be heard by people, not to be rhetoric or anything like that. I think we're in as much risk of nuclear weapons going off in the next weeks or months as we've been since the Cuban Missile Crisis. When the CIA says there is no threat of Saddam using his weapons of mass destruction in the near future, whatever he has, which does not include nuclear weapons as far as we know, against US or its neighbors, if not attacked, but that there is an almost certainty that he will use what he has if and when attacked, which the president is going full blast to do. There's very great modesty or reticence on the part of the newspapers to say what will happen then. The New York Times has said several times that raises the question of how Israel would react if significant casualties are caused by chemical weapons or biological weapons by Saddam if and when we invade him, or what the US. And all anybody will say is there's a question. Well, let me answer that question, not with certainty, of course, but with a dangerous probability. When the US and Israel both say that their answers to significant casualties from chemical weapons would be to annihilate, that is, the greatest act of terrorism since Nagasaki or a few others, but to annihilate Baghdad, to destroy Iraqi society, they are talking nuclear weapons. And I don't believe that either of them is totally bluffing. Now, all of this is a contingency. It's uncertain. It's uncertain if Qassam has the operational capability to deliver and cause great casualties with chemical weapons when faced with his own destruction by us. It's uncertain, as Tenet says. It's a gamble. It's a gamble that Bush is clearly willing to take. And Rumsfeld and Cheney, my impression is that his own father was not willing to take that risk in 1991, and that Powell wouldn't prefer not to take it today. But we are facing that risk, and it is up to us, I think, who else, to really block that. So the general point I wanted to make, and I'm going, okay, 2 minutes beyond it. The general point is, we are in fact in a very dangerous world. Bush says that, but that's true. Al-Qaeda, in my opinion, is a very dangerous threat to this country. The idea of Al-Qaeda getting nuclear materials is very ominous, or hitting a nuclear power plant. Indeed, that risk can only be made greater by the invasion of Iraq. In fact, there's almost no chance that Al-Qaeda could look for nuclear weapons from Saddam if not attacked, but there is a lot of danger that they could get it if they are attacked. Otherwise, their source would be Pakistan, or spare missiles and nukes, I mean, not missiles, but nukes and so forth from Russia, et cetera, et cetera. So there are real dangers which are all increased. Contrary to what the president is saying, surely non-proliferation is not among the objectives of this campaign. It can only be set back. And so the last point I wanted to make was that things that David has been saying, and Richard, longer than anybody else I know, about the need for world order, for a world of law, and specifically for the abolition of nuclear weapons, the reduction of the danger, have been right from a long-term point of view and a mid-term point of view for 40 and 50 years, or as long as they've been saying it. But that is urgent at this moment, talking about the short run. We cannot afford certain policies that have always been wrong and always dangerous in the long run. We cannot afford anymore. The U.S. nuclear policies, the U.S. first-use policies, Israel first-use policies, India and Pakistan's first-use policies, we cannot afford to turn our back on significant measures of moving toward the abolition of nuclear weapons, because the crisis demands it right now. So I'm very happy to be able to salute your incident. I didn't even know Dick was chairman of the board here, but very good, one of the many things. But, and Jackie and all the people who've been working for this. But we're not looking at the long term. It's essential that there be a challenge to these policies right now, and in the next 2 weeks before the election, is it as much as 2 weeks yet, or what is it like? The Democrats must be told this is not the way to run for president. This is the time they will hear that. Senators like Dianne Feinstein must be told compromise on this issue is not acceptable. We will do everything we can to elect, she's not up, I guess, but the representatives that oppose, representatives that have betrayed us in this case. One of the other policies we can't afford, of course, anymore is our support and financing of the occupation of the West Bank and Gaza, but that takes us a little further afield. All of these things are going to cause U.S. casualties and foreign casualties in the short run if we don't avert this war. So that has the highest priority of all, and that's why I'm leaving early tomorrow to take part in a rally in San Francisco, which has sponsorship, by the way, that I'm not real keen on in some respects, but this is a time for coalitions, this is a time for averting this war, and I'm very happy you're having this conference right now. Thank you.
I'd like to ask Richard Falk to come back to the podium and make a few final comments. Richard.
Let me begin by saying that I think what Dan has just said is gives a very important kind of culminating focus of political and moral urgency to what we've been talking about all day. And I think I've found the presentations throughout the day, with the exception of the first one, extremely stimulating, and it's been a really superb symposium on very difficult issues, and I think addressing a very wide range of problems that we all as citizens should be devoting as much energy as possible to. I want to make just 5 very quick points that come out of the discussion during the day. And I want to start with something. In one respect, I don't think Dan went far enough when he said his objection to, part of his objection to Senator Kerry was that he was willing to endorse recourse to war in the event that the UN withheld its authorization. I think it's very important to take a stronger position, say even should the UN give its authorization, it is still an unlawful war. And I tried to say in my own presentation that the UN has been presented itself with an ultimatum: either you rubber stamp US geopolitics or you become irrelevant and the US acts on its own. And so it is a challenge to the integrity of the UN, but I think it doesn't change the aggressive nature of what would be done to Iraq. And I think it's important to make both levels of argument against supporting such a policy. Many of the presentations during the day, I think, have groped for ways that, despite the discouraging and dangerous atmosphere that exists at the moment, that we can still be hopeful. You know, how do we sustain hope in the presence of this kind of gathering storm, in effect? And I've also tried to address that issue in different ways, and I think one of the important ways to think about making changes in the world is to conceive of politics not only as the art of the possible, but the art of the impossible. And by that I mean, if you look back 20 years ago, it was impossible to imagine peaceful transformation of South Africa's apartheid system, or the end of the Cold War, or the freedom of East European countries. Those were all impossibilities that happened only because people believed they could happen. That is, the commitment to the impossible is what changes the horizon of feasibility. And so therefore, it is of, I think, great importance not to be trapped in a failure of imagination by accepting conventional wisdom as to what is possible at any given time. And I think the example of the International Criminal Court that President Robinson gave himself was a further example. The project of the International Criminal Court was an impossibility. It struck people as utterly absurd to think that, given the way geopolitics was configured, that the powerful countries would let this happen. But things happened that they didn't anticipate, and it came about. So I think we must keep open that sense. I want to make just a couple of comments about the Nuremberg tradition and how it was, there was, I think, some suggestion that between the Nuremberg judgment and the International Criminal Court, there was a kind of forgetting of the Nuremberg experience, and that it had been reduced to mere rhetoric. I think that underestimates greatly the role of activists during the Vietnam period in keeping the Nuremberg tradition alive. Many people in America, and Dan knows many of them as well as I do, I testified in many of their trials, went to jail because they believed they had a Nuremberg obligation to act in defiance of an aggressive war, in this case, the Vietnam War. And very inspirational figures like Daniel and Philip Berrigan, the Catholic priests, or James Douglas out on the West Coast in Ground Zero, they deserve to be acknowledged as part of this process that has kept alive the Nuremberg idea, and which has been carried further, of course, by the International Criminal Court. I think there's another point that needs to be mentioned, especially by Americans in the United States, and that is when we look back, and I think Judge Egley touched on this in his remarks, that Victor's justice is not real justice, but it was particularly not so in the context of the Tokyo war crimes trials. Because if there's one thing that, for most of the world, was the other atrocity, other than Auschwitz and what happened in Germany, it was the initiation of the nuclear age by dropping bombs on essentially undefended civilian cities in Hiroshima and Nagasaki. And to exempt that from the prosecution, to exempt that, was to create a sense of hypocrisy and double standards that was very widely perceived. And if everyone should read the dissenting opinion to the Tokyo war crimes trial written by the Indian judge Pal. It's a really historic document, and because it's such a devastating document, it's extremely difficult to obtain. I just recently have reread it. It's very long. It's about 600 pages, which is sort of lengthy even for a dissent in an important case. But even the Princeton Library, which is a famous library, didn't have a copy. I had to borrow it through interlibrary loan. And it's just illustrative of the degree to what happened in the Tokyo trial was that the victors lost some little bit of control over the process. In Nuremberg, you had only the 4 Allied powers as judges. They made the mistake in Tokyo of having an Indian judge, very distinguished jurist, but from a country that was a colony at the time, and looked at the whole Pacific War through a different lens. And the perspective you take on these issues is very decisive for the way in which you address these issues. And he saw no difference between the victors and the defeated as far as culpability was concerned, and therefore he couldn't bring himself to find any of the defendants guilty. And the third thing I wanted to mention about the Nuremberg legacy is to recall the promise made by the American prosecutor, Justice Jackson, which I've called the Nuremberg Promise, which was that to overcome the limitation that victor's justice had at the time meant that those that were sitting in judgment pledged themselves to accept that framework for themselves in the future. In other words, that this was a deferred acceptance of mutuality and reciprocity as the foundation of justice. And we have broken that Nuremberg Promise, and I think that's something that's very important to mention. Just one point about the Non-Proliferation Treaty regime, which I think is very important to subject to critical assessment. I think it was Cecilia Lynch who said we shouldn't underestimate its it's done some good things, or something like that. It's arguably inhibited some proliferation of nuclear weapons, but it's also created a context in which the nuclear weapons states have been relieved of their commitment to get rid of nuclear weapons. And it's created the false impression that the danger of nuclear war comes from the countries that don't have the weapons rather than from the countries that do have the weapons. In that sense, it's one of these kind of Houdini things where you have changed the sense of where the real problem is. Or like the shell game, where you can't tell where the shell is. And so I think we need to acknowledge that the United States and other nuclear weapon states are in material breach of the Nuclear Proliferation Treaty at this time. And material breach has a nice resonance now, because that's what we say Iraq is doing in relation to the resolutions governing the inspection of weapons of mass destruction facilities in its country. And I think this material breach is especially pertinent given the nuclear weapons posture statement that was released. John Burroughs, I believe, referred to it at some point about lowering the bar for the U.S. first-use nuclear weapons policy. Not only are we not willing to fulfill the pledge to engage in a good faith search for nuclear disarmament, but we have intensified or tried to validate our own reliance on nuclear weapons as instruments of policy in the future, and have created a much greater danger of first use in the near future, as Dan very well pointed out. The last point that I wanted to make was to just say a couple of words about the very interesting observation that President Robinson made about the fact that a new civilization is taking shape around us, whether we acknowledge it or not. And what the shape of that new civilization is itself, I think, something important to think about. He emphasized science and technology transforming our sense of the real. I think Mark McGuinness, in a different way, talked about a civilization that is engaged in a collective process of extraordinary ecological denial that is unable to realize that it's destroying the basis of its own survival. And we have to ask the question, is this kind of new civilization a demonic one that is basically suicidal in its implications for the future? And we also have in that setting these very disturbing issues that touch in a way on the ecological perspective, but in a sense go beyond it by raising the question of what is it to be human, the possibility of human cloning, the kind of boundaries that science is crossing, science and technology are crossing, robots that can outthink us and outfeel us possibly, all of these frontier possibilities really suggest something very radical that's happening underneath the preoccupations that we need to have to address these urgent crises in matters of weeks, months, and years. But we also, I think, in thinking about the situation that we find ourselves in, have to address the radical challenge of an emerging civilization that we don't begin to understand. Thank you very much.
Richard, thank you. I just want to add a few closing words. When we began the Nuclear Age Peace Foundation 20 years ago, the first booklet that we published was called Can We Change Our Thinking? And it was based upon the famous quotation by Einstein that the splitting of the atom has changed everything save our modes of thinking. I've often come back to that quotation of Einstein's and wondered what it is that he was calling for. What was the change in thinking that's necessary for us? And it occurs to me powerfully from the presentations today that one of the key elements to that change is the double standards that we continue to live by, the double standards that are so evident in our policies, the double standards that if you look back at the justice we imposed at Nuremberg and you compare it to the actions and policies of our government today, I think that there's a reasonable expectation that we wouldn't as a society live in such complete hypocrisy that we're willing to apply standards, impose standards on one set of people and exclude ourselves or make ourselves exceptions to those very same standards. And I want to emphasize once again that if you have a standard that says you cannot commit aggressive war, that shouldn't be a standard that only applies to those countries out there and doesn't apply to us. Because if we're willing to impose penalties on others for committing the same acts and following the same policies that we're willing to pursue ourselves at a different time and a different place, then all that can be said of us is that we not only fail to live up to our own standards, but we live in the deepest state of hypocrisy. And I think it's extremely unhealthy for a society to live in that kind of deep state of hypocrisy, because ultimately, if you live with hypocrisy, you can't respect yourself, you can't respect your system, and you lose the sense of decency and of value in that system that you can only come to see at some point as hypocritical. Now, I want to tell you, I'm wearing a button today that says "Choose Hope." It happens to be the title of the book I wrote, Dan. And I think that the idea of choosing hope is extremely important, because hope stands in stark contrast to despair, to cynicism, to ignorance, to apathy, to complacency. And all of those latter things, the ignorance, apathy, complacency, despair, are really fertile breeding grounds for hypocrisy. And if we want to break out of that hypocrisy, if we want to get into that new way of thinking that Einstein warned us we needed to do, or we are going to face unparalleled catastrophes, I think we have to start with choosing hope. So for me, this has been an extremely hopeful day. It's been a day that's been filled with promise. It's been a day in which we've really examined some very serious problems that face our society and which face our world. I want to thank deeply all of the panelists from this afternoon, from this morning. I want to thank Richard, President Robinson, John Burroughs, Dan for joining us. It's in many ways been an extraordinary day in which we've come together to focus on critical problems that face us. I hope that all of you who have given your day to being here with us have gained from this, will take some new knowledge away with you, will take some inspiration from the day, and will go forward to try and do all you can to cut through these bonds of hypocrisy so that we can eliminate double standards from our world and try to create a world that's much more based on human dignity and decency, compassion, and so forth. To do that is going to take not only commitment, but courage, because when you go out to fight against hypocrisy, you may find that you're accused of many things that you won't want to be accused of. So have courage, have heart, go out and help change the world, and thank you all very much for a great day.